Well, good evening, everybody. Thanks for your patience. My name is Barbara Kessler. I'm here from the Massachusetts Office of the Attorney General and to talk about landlord and tenants' rights and responsibilities. I am from the Community Engagement Division, so my job is to go out into communities like this one. And I'll just let you know a little bit about our office before we get into the topic here. This is our Attorney General. Andrea Joy Campbell was elected for a 4-year term, so it is an elected office. The office itself is over 600 employees, not all of whom are attorneys. I am not an attorney. Maybe about half the office's attorneys, and the rest of us are doing various jobs like investigating and advocating for consumers. And the Attorney General's office is an advocate and a resource for all residents of the Commonwealth, regardless of status, regardless of where you live. And the work that's being done is involved with protecting consumers and combating fraud and corruption, investigating and prosecuting crime, and protecting the environment, workers, and civil rights. And so how does it work? We have 4 main areas in which the work falls in order to protect the public and enforce the law. It starts often with an investigation. Sometimes that might be a complaint, for instance, about a landlord from a tenant. And that might get involved with a consumer advocate trying to work with the tenant and the landlord to find a solution, or it might be a complaint about wage and hours to our Fair Labor Division, which is one of the divisions of the Attorney General, and then that complaint might lead to some kind of an enforcement. Sometimes it's as simple as just having an investigator go out and require that a employer pay what's owed after an investigation. Sometimes an investigation can grow into a bigger enforcement, right? So there may be a pattern that's uncovered with a particular employer or a particular business that might result in something bigger, like a bigger fine or some kind of legal action or a lawsuit. Policy is the piece of our work that we don't directly do. We do not write laws, but we do inform the work that gets done by the legislature and what we uncover in our work in terms of what rights need to be further protected in the Commonwealth. And then the 4th piece is prevention, which is my job here, right? It's going out into the community, going out to the public, let them know ways that they can best advocate for themselves in all these areas, and to be armed with the knowledge of what's right, what's the law require, and what protections they are offered under the law. So that's just a little bit about the work. Where are we located? Our main office is in Boston, but a lot of people don't realize we have 4 regional offices. There's one down in New Bedford, one out in Springfield, and then right here in Worcester County in downtown Worcester, which is the office that I'm based out of. And all of the offices are open to the public. You can go in and you can speak to somebody, you could file a complaint, you could get some information or resources regarding a particular topic simply by going into the office. And this is basically a quick disclaimer just saying that we do not provide legal advice. This is not intended to be any legal advice for your particular situation. If you had any kind of landlord or tenant issue or any issue, we would always advise to seek the advice of an actual attorney. In fact, the Attorney General's office is not allowed to give private legal advice. That's not our role. We're the attorney for the state and in such the chief law enforcement in the state, but we do not work on an individual basis. If you were to work with somebody in our office regarding a landlord and tenant complaint, it would most likely be a consumer advocate who would be trying to come to a solution with your landlord on that particular situation. That's not, so anything that I'm speaking about today is not legal advice. It's more general about the law. And here we go. How's it all work? We are going to start with the types of tenancy. Basically, there are two types. There's a written lease, right, which many of us are in that sort of situation. It's got a specific term period where it lasts usually for a year, but it could be other times. And then during that time, the rent is not going to change. It's going to stay the same for the entire term of that tenancy. And it involves, like we said, a written lease. The second type of tenancy is called tenancy at will. Sometimes there's not even a lease. It's more of an agreement. And it lasts as long as both parties want to continue that arrangement. And the rent can change, but with a 30 days notice, right? So whereas a tenancy based on a lease, there can be no change during that term of that year-long lease. So even with the tenancy at will, if there is no written agreement, we of course always recommend that agreed upon terms do get put in writing, and sometimes there could be something like a memo, if not a lease, at least something written that both parties can refer to. And it's a very good practice to have everything pretty much throughout your whole relationship with your landlord documented in a paper trail and in some kind of written agreement. So we're talking about the form of a tenancy at will agreement or a rental agreement, and have some kind of written memo for yourself. Okay. So a rental agreement must include name and address and phone number of the owner, of course, the owner of the building. It also must have the name of the person responsible for any maintenance. So that's not always the owner, right? So that needs to be shared with the tenant in writing. And the phone number and contact for who to make any kind of formal complaint to, or to present any kind of court papers. So there's specific requirements for what the lease cannot say. The lease must not contain illegal terms such as the tenant must pay for the cost of repairing ordinary wear and tear to the apartment. The tenant must pay for repairs to parts of the building beyond the tenant's apartment. The tenant may not sue the landlord or report violations of sanitary code. None of that is legal. That cannot be put into a lease agreement by a landlord. And it can't charge can't put a late fee in the tenant in the lease that says you must pay even if you're 1 day late. So there can be a charge permitted if rent is very overdue. But they can't put those kinds of addendum inside the lease. So you should read over the lease very carefully. Now the obligations of the landlord versus the tenant, right? So the tenant has obligations too. The tenant must pay rent, and they must follow any of the rules that are agreed upon with the landlord and that are written in the lease. And they must accept responsibility for damages beyond normal wear and tear. The landlord must provide an apartment that is safe and clean and in compliance with the sanitary code. Okay, so it's very clear. We'll talk a little bit more in detail in the further slide about what the sanitary code requires, but that is the landlord's obligation. And they must live up to any promises that are made in the rental agreement. Okay, so what is required of a tenant at the beginning of a lease or beginning of a tenancy? The landlord can charge first and last month's rent. Not all landlords do. Some landlords might just charge that first month's rent. And then a security deposit, and the security deposit can equal no more than 1 month's rent. And they can also, the key refers to a lock or change lock fee. So when you're taking over a new apartment, if you're requiring that the landlord puts in a new lock and key for you, then you can be charged for the price for the new lock and key. landlord should provide receipts. So that's super important, as we talked about before. Anything that's discussed or that's negotiated with the landlord, we should put those things in writing. The landlord's responsibility would be to put those in writing, and the tenant has that right to demand that that they get a receipt for anything paid up front. Okay. And here's the thing also, at the beginning I'd said my name, right? Barbara Kessler. It's really easy to reach me at the AGO, barbara.kessler@mass.gov if there's anything that if I don't know it, again, not being a lawyer or a consumer advocate, I could certainly look up that detail and get back to you. I'm happy to do that. I do that all the time. And I learn new things at all of these presentations because situations are unique and things come up that I hadn't heard of yet. Let's see, security deposit laws. So give the tenant, the security deposit law requires certain things. Yeah, I didn't skip anything. Okay, back to this. The tenant has to be provided with the name of the bank and the address, as well as the account number for where the security deposit is held. So the security deposit does belong to the tenant, and they have the right to know where that is being held, and they also have a right to get the interest on that account. So at the next bullet point, it says each year either pay the tenant the interest on the security deposit or let them deduct that amount from a rent payment. Now some tenants will choose to just let that accumulate, and when they eventually end that tenancy, when they get the security deposit back, they will have access to that bank account and be able to see what interest is owed them if it hasn't been paid out along the way. The landlord also must give the tenant a statement of condition, which describes the condition of the apartment and any damage that exists at the start of the tenancy. And they must also return the security deposit plus the interest within 30 days of that tenancy ending. So those are the rules regarding the security deposit. A statement of condition, of course, is a super important thing for a tenant to be mindful of when they're moving in. So they take inventory with the landlord of every cabinet pull, every tile, to make sure that any pre-existing damage gets noted and it doesn't get charged to that tenant's tenancy. And it gets marked as a pre-existing condition, basically. And so I guess the landlord should give the tenant a statement of condition within 10 days of beginning the tenancy. So there is a bit of leeway there. Or upon receipt of the security deposit, whichever is later, which describes the condition and any damage that exists at that time. The tenant then has 15 days to add to that statement of condition or make changes to it. And both parties should keep a copy of that final agreed upon version of the statement of condition. So questions and information you should consider about renting. So if you're a tenant, you want to ask whether utilities are included. Is the responsibility of paying for the heat and the hot water up to the tenant, or is the landlord providing any of that within the price of the rent? You should determine whether it's electric or oil or gas or propane, and determine you can also find out if there's any way to determine what the approximate cost of that utility might be. And is there, for instance, a parking space that comes with the unit? All of that should get discussed ahead of time. If amenities are present, what are the additional costs associated with access? So as it says here, in Massachusetts, a landlord cannot require a tenant to pay an additional monthly fee for amenities on the property, like private parking or a pool or a workout room, but they may restrict access to those who have agreed to pay. So they can't require you as a tenant to pay for that, but they can restrict access if it's only for those who have paid. If repairs are necessary, both parties should discuss whether the landlord will make those repairs before the tenant moves in. And and the landlord and the prospective tenant together should check every plumbing fixture, light switch, cupboard door, whoops, and appliance to make sure they all work properly. Similarly, the lease or rental agreement should include a list of all repairs and a time frame to complete that the landlord agrees to make during the tenancy. The lease or the rental agreement should also note if major appliances are included with the tenancy, such as a washing machine. So sometimes there will be a hookup, for instance, in an apartment, but the landlord is not providing a washing machine. You should find out at the beginning whether or not you have the right to hook up. Some, for instance, a landlord might have an issue with you using that hookup because there's some kind of, plumbing problem that they don't want to address. You should determine all of that before moving in, whether or not you're able to hook up your appliances to anything available there. One note about having any repairs done after the tenancy has begun, after the lease starts, you should not, have a family member or somebody coming into the apartment to do those repairs without some kind of prior approval from the landlord, and especially in any case where there is a licensed electrician or a licensed plumber that needs to be used. All of that needs to be very up and worked out with the landlord in terms of making sure the tenant is not liable for anything that goes wrong and having a repair made. Okay, information regarding pets. Does the landlord allow tenants to keep pets in the rental property? Will a landlord require a tenant to pay a higher than advertised monthly rent to keep a pet? That's something that should be talked about in advance. I guess Massachusetts is a little bit more pet-friendly than it was in the old days. They're technically not allowed to charge a pet fee, but they can charge a higher fee, a higher monthly rent, or a one-time charge. Let's see if I can explain it here. One-time pet deposit is not allowed. And a security deposit cannot exceed 1 month's rent. So you can't say, this is your security deposit, but I'm going to tack an extra $250 on it for the dog. The security deposit can only, as we said before, can only equal 1 month's rent. But they can, if they advertise it and they're being legit about it, say that the rent is going to be slightly higher because you have a pet, because of the wear and tear that may cause throughout the year. But it's not, you can't agree upon a rent with a landlord, and then once you start moving in and they see you have a kitty litter box, like, oh, I didn't know you had a cat, I'm going to jack the rent up. That's not allowed to change the rent afterwards. So you really need to have all of those discussions out at the outset. For any reasonable accommodation issues, please contact our Civil Rights Division. So that would be referring to, since this is on the pet slide, any kind of emotional support animal or something that you have, a medical condition where you would require to keep a pet in the home. If you need assistance with that, we do have a Civil Rights Division that helps. So for instance, you can also make reasonable accommodations for other things. A request for a reasonable accommodation. So for instance, if you needed a bar by the bathroom, tub or toilet, you can, if your landlord's not participating with that, you could actually ask for assistance from the Civil Rights Unit in our office. So this is the state sanitary code that we briefly touched upon earlier. The sanitary code governs what it means to provide a habitable place in Massachusetts. So in general, habitable means that it's comfortable and clean enough for a person to live in safely. If a sanitary code violation isn't addressed by the landlord, the tenant can request an official to inspect the unit. And then if a landlord still fails to fix the problem after an inspection and a violation is found, a tenant may be able to withhold a portion of the rent or move out. So, of course, an inspector can come after the public health or the inspectional services office has been contacted. All complaints should be in writing leading up to that point, right? So every time you make a complaint to your landlord about a specific issue, you should put that in writing and follow up after the inspection has been taken place. So if in the event that the landlord still doesn't fix the problem, a portion of the rent may be able to be withheld, but we really do recommend before doing anything on your own about that you do consult a private lawyer to figure out how to do that and whether or not it is appropriate to do that. We also always encourage people, if you are making a sanitary code complaint and you're having an inspector come to the unit, make sure that it is spotless. The unit is spotless, right? So if you're hoping that the Board of Health is going to come and cite your landlord for a problem, you don't want them to also be able to cite you for a problem. Oh, well, this is a mess. You know, there could be a pest problem because this is not being kept clean and tidy in the bathroom or in the kitchen, right? So if you're having, you're escalating to the point where you're having an inspector come, you want to make sure you keep the unit really clean and neat in that case. So recent changes to the sanitary code went into effect this year, and those changes involve these particular categories, or they've become strengthened. So there's protections against pests, moisture, right? So in case there's some moisture coming through the ceiling and any kind of leak or any kind of issue in the bathroom, that you know, an area of moisture could indicate that there could be a problem that could lead to mold. And so the landlords must inspect for pests before new tenants move in. And Board of Health inspectors may check any observations of mold or conditions of excess moisture. And the landlord must provide, so the kitchen category is that the landlord must provide an oven, cooktop, and a fridge with a freezer. That's required to be in the unit. And then also there is heating requirements. So the heating has to be available to be used between September 15th and May 31st. And it must be at least 68 degrees between the hours of 7 a.m. and 11 p.m., or at least 64 degrees between the hours of 11 p.m. and 7 a.m. And the landlord must make a good faith effort, that's the repair piece, to correct any dangerous or unsafe conditions within 24 hours. The landlord has to give a number to all tenants that they can be reached on, that they check at least every 12 hours. So when you move in, that's one of those first things, one of those first slides, the landlord must provide you with that information. Who to contact and how if there's any kind of repair issue or any kind of problem. And that's what the cell phone, the landlord response is about. And again, any requests that you make of a landlord, keep those in writing. So you could do it, I mean, a text or an email or a letter, some record of the communication. So in terms of addressing conditions, you can notify the landlord and in writing, again, to request that the problem gets fixed. And then keep a copy for yourself, right? So you're sending an email or a letter, make sure you have a copy of that for your records. If your landlord doesn't fix the problem, then you can move to the step of contacting the local Board of Health. And then if that doesn't work, you may be able to file a case in housing court seeking an order that requires the landlord to complete these repairs. So then frequently asked questions, can I withhold rent? Can I make the repairs myself? Again, if the rent is withheld, you should always keep those funds aside. It doesn't mean that you get a free month, right? It means that you're using That is power to hopefully have that landlord take the action that they're required to do. You will then most likely have to pay some of that rent, probably an adjusted amount. And so that money that you'd put aside of unpaid rent would have to go towards paying up after that repair is made. And again, it would be some amount that gets determined based on fair market value of what the house was worth when it was in poor repair. And you should also notify the landlord of when the Board of Health inspector is coming. A lot of times what I hear from the consumer advocates that work in my office is that some of their work is actually educational to the landlord. Landlords aren't following the rules because sometimes they just don't know them. So it's really important to try to work proactively with your landlord and not treat them as an enemy that's purposely ignoring your requests. Give them the opportunity to make it right and let them know when the inspector is coming. And hopefully get the problem taken care of without having to go through further legal action. As you can see on the bottom here, remember it is illegal for a landlord to retaliate against a tenant for taking an action to make their home safe and livable, which is required by law. So retaliation is not permitted by law. So the right to withhold rent when a landlord fails to maintain a dwelling in habitable condition, a tenant may properly withhold a portion of the rent from the date the landlord has notice of this breach of warranty of habitability. So that's the legal term, warranty of habitability. So they're making a promise, right? It's their responsibility to provide a habitable dwelling. And so that is the basic term. So if these situations are met, the Board of Health is inspected, they have found violations, and they have notified the landlord, yet the violation is not corrected, and the tenant is current on their rent and is not causing the problem themselves, and the repairs do not require you to have to leave to have them done, then withholding rent can be a possibility. Now, in terms of getting legal advice on this, again, we are not in a position to recommend lawyers, but we do know, and we will have some resources at the end of this slideshow, that each community has legal services, and the Mass Bar Association has a referral service where you can find an attorney to ask about what your best practice is in these cases. Making your own repairs. If the Board of Health has certified that conditions endanger health, and you have already notified the landlord in writing, and the landlord has 5 days to begin or contract repairs. And if they agree with you that you can do your own repairs, if again you've discussed that up front, you'd have to keep all of your receipts, and the costs of repair must be reasonable. And you can deduct no more than 4 months of future rent. Yeah, so keeping your receipts if you make repairs and deduct that from the rent. If the costs are deemed to be unreasonable, you will only be able to deduct that portion which is reasonable. If you qualify under the requirements of repair and deduct, you may treat your lease as void. You then have the right to move out if you choose not to make repairs. However, you must make the fair rental value for the period you occupied the apartment, and you must vacate within a reasonable amount of time. So this slide refers to the assistance, the energy assistance that is available for renters, known as LIHEAP. It's a fuel assistance program. And it provides eligible households with a portion of winter heating bills. That is something that you can find at toapply.org/massLIHEAP. And I believe that the application opens in October for the upcoming heating season. So again, it makes funds available for people who cannot afford the utilities. There are other ways to get some assistance. There's a budget plan that people can apply to, for instance, like with National Grid, that tries to make a predictable monthly plan for utilities. And you will have it, so if 1 month you're paying more than you actually used, you'll get a credit. If you're using a little bit more than that, then you'll have a little bit more owed. But it's an attempt to try to make utilities more predictable throughout the year. There are also other organizations that do provide funds. I think United Way is one, and FEMA is another that I've heard that sometimes has funds for that kind of relief. There's also state rental relief, and this is called the Residential Assistance to Families in Transition, RAFT, and it allows a tenant who's applying to get up to $7,000 for their household. And that RAFT, if they are awarded that assistance, it can help with past due rent, future rent, utility bills, moving, furniture, or startup costs. And the RAFT program helps keep households in stable housing situations when facing eviction, loss of utilities, and other housing emergencies caused by loss of income. Whoops, went too soon. RAFT funds may be available to households with incomes of up to 50 or 60% of the area median income, or AMI. So that's something that your landlord does have to assist with, too, if you are working. You need to have your landlord complete their portion of that application, and it is a timely process, so they may, you may need to continue to get stay on your landlord to help you apply for that. And if we are landlords, then you definitely want to participate in that process in a timely manner, because everything has to get submitted in terms of the proof of ownership of the home and various things in order to go through that process. And a landlord cannot, discriminate based on somebody needing rental relief from the state. And again, that's that word, it's retaliation. Your landlord cannot evict you for exercising your rights. So, like, for instance, making a complaint about a condition. So eviction is a process. A lot of times, people don't realize it. Really, it's a court process that has to happen, and it has to follow a series of. Has to go through this process. The landlord must give a 14 or 30-day notice to quit, depending on the reason for the eviction. That notice has to be given, and then that would start the court process if a landlord files a civil action in court. Basically, a landlord doesn't really want to have to go through the process of an eviction. It's a costly process. There is mediation available at the outset of this that can be assisted at the court level to try to avoid having to go through the whole process. Sometimes it can be worked out between a landlord and tenant when rent is overdue, and maybe a payment plan can be worked out or something like that. But you can't, a landlord can't just simply say to a tenant, that's it, move out. They have to go through these specific steps. So there's a notice to quit. For non-payment of rent, can be a 14-day notice. For other reasons, it would be a 30-day notice or one full rental period, whichever is longer. And then the landlord must get a judgment from the court with the date the tenant must leave by, and then the tenant has a right to raise those defenses during that process too, defenses to that eviction. The formal eviction process is called a summary process, and it starts when the landlord files that complaint in court. So some common defenses to eviction include failure to properly terminate the tenancy, meaning going through those proper steps, the landlord failed to correct a known condition, or the landlord is evicting you in retaliation for activities that are protected by the law, or discrimination, including that the landlord failed to make a reasonable accommodation to allow a disabled person to remain in home despite their ability. So those are some common defenses to the eviction. And so basically one of the things that our housing unit does in that consumer protection division that I talked briefly about before, one of the things that they do mediate a lot is landlord-tenant complaints. So you do have the ability to ask for help at the Attorney General's office. So your landlord does need a court order to evict you. That's the first thing you need to know. And if your landlord tries to make you leave your home without a court order, or you need help applying for rental assistance, you can fill out the form at the website, which is the link right there. And that's the little guide that I handed out here today. It's very easy to reach the Attorney General's office. You go to mass.gov/AGO, and that takes you to the home page. All of the complaint portals are right there on the home page. You scroll down on that very first page, and it says, what would you like to do? The first button is file a consumer complaint. Then there's file a workplace complaint, and then there's file a civil rights complaint. Anything to do with a landlord and tenant would be a consumer complaint. So it's very easy to reach our office. Housing discrimination is involved, and that is unlawful when a person's race, color, or national origin, ancestry, gender, marital status, religion, age, sexual orientation, gender identity or expression, or military background or disability is discriminated. That's the basis. Those are the protected classes, right? So it is important to keep documentation of any incidences where you felt you were being discriminated against, and to keep a record of those in case you do have to file for assistance in any case. And I mentioned briefly on that financial assistance page, it is unlawful for your landlord to discriminate against you for receiving financial help. So your landlord can't discriminate against you because you receive government benefits. If your landlord refuses to accept RAFT or refuses to fill out their portion of the application, they may be violating Massachusetts law. And to report any discrimination, you would call the Civil Rights Division. That's another division within our office. Again, one of those buttons on the homepage has all of our various complaint processes and hotlines on that form. Just a brief note about housing scams. You want to avoid sending money to anybody that without, seeing the property in person and dealing with a legitimate person with a lease. And you don't want to wire money or transfer money. I guess it's one thing, it's very hard to trace any money that's been wired or transferred in that way. And I do see that as a common scam. I'll hold the apartment for you, just wire this money now. Just be super aware when you're looking around for houses. In general, we do a lot of scam presentations to all populations about different topics. And if it sounds too good to be true, chances are it's a scam. So be aware and do not give out your payment information or your Social Security for somebody just online. And if you are the victim of an online apartment listing scam, you can file a complaint at ic3.gov, which is the Internet Crime Complaint Center at the FBI. And then we just basically have our resources. The guide, which is also available online, but again, you can take one here tonight. And we also have a multilingual resource too. So if you know anybody in the community that doesn't speak English, wasn't able to come to this presentation tonight, they can go on our website. And again, it's mass.gov/AGO/language, and you'll get assistance and forms in many different languages. Some other things to be aware of for housing conditions, again, you want to contact your local Board of Health or inspectional services. For rental assistance, you can check into the, used to be the Department of Housing, and now it is called the Executive Office of Housing and Livable Communities. For help regarding eviction, again, you can file a complaint with the Attorney General's office, the way I just described, or you can contact legal services or legal aid in your area. And legal assistance, again, masslegalhelp.org is one of those places where you can find a lawyer, or you can find community legal aid in the town. If you have a certain income threshold where you make below a certain amount, you may be eligible for free or reduced legal help through legal services or community legal aid. And then there's the Mass Bar Legal Referral Service. And that is it. I think basically all of the numbers that you will need to reach us are on that page that I left at the front of on the table in front. And again, drawing your attention to the main consumer-facing, public-facing divisions. We have the consumer advocacy division at the Attorney General's office. We have a fair labor division that handles complaints in the workplace. The civil rights division, again, about your protected civil rights. And the healthcare division, which enforces health insurance and healthcare billing problems. And an insurance and financial services division. Actually, the other way around, yeah. Insurance and financial services division will offer protections to consumers regarding their insurance. So that's it for tonight. Any other thoughts or observations, please come up and feel free to let me know. And I can certainly take notes and get back to you with the answers. So thanks for coming out.